Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you determine whether or not you can handle some issues yourself. If you do decide to seek professional counsel, the idea is that you'll be better prepared, and so will the professional you select. Either way, you'll save time, money, and hopefully achieve the best possible results. We continue to welcome and thank David Bazar from the Bazar & Associates law firm in East Providence, who continues to give us his information and insights on the various issues that we tackle. So today, the questions you ask every day, answers, we have them. So whether it's at work, money, court, police, your divorce, a potpourri, so to speak, the everyday issues that you grapple with, we're going to explore some of the scenarios and get some of the legal insights that may help you handle some of your issues. So the first thing, David, this is going to be an easy one, or maybe not, so I'm not sure. I'm sorry. We're taught that an apology is often a very good and appropriate thing to say if you need to respond when something bad happens or if someone's hurt. We've sort of talked about this before, but what are the legal ramifications of this kind of gesture? If you have a car accident, or as I think we tackled before, the executive director apologized to, what was it, James Woods, when his brother passed away and there was some possible neglect. Anyway, what happens when you say, I'm sorry? What are the legal ramifications?
So we actually did talk about that before in the medical malpractice world, which was the James Wood case and the hospital where his brother passed away. And, you know, the traditional thinking had always been, don't say you're sorry because that's like admitting fault and you don't want to do that. But there is a couple of things, and there was some look at whether or not even the law would be changed so that that's not an admissible thing. But the long and short is, from a practical standpoint, people have really sort of taken the position that it's okay to express sorrow. It doesn't necessarily mean you're expressing an admission of guilt or liability. If someone dies, it's okay to say, I'm sorry for your loss. You're not saying, I'm sorry that we caused the loss of your loved one. So that's some of the thinking that has gone into advice that's given to people about whether or not to apologize for something. When there's an accident that happens on the road, you generally see less of the lawyers advising a client to say, I'm sorry, because on the road, that could be taken as, I'm sorry I hit you. Whereas opposed to, you might be saying, I'm sorry we had this accident and you and I are both in that position, and it's probably too nuanced on that situation. But in the corporate world, that's really where the I'm sorry kind of approach can be taken and has really changed how we really approach those types of things.
So would you say if someone has a car accident, unless you can say, I'm sorry that this happened, comma, but we both are in a bad situation, I'm not sure that everybody thinks, but is that the only way or the only circumstance?
I mean, no matter what you say, it's going to be he said, she said usually, because many times people come into my office and say, I was in an accident, the other driver apologized for hitting me and took responsibility. And then, of course, you get to the deposition of the other driver and they've been counseled by their lawyer and they'll say, no, I didn't. I didn't even say I'm sorry. I didn't say anything. I didn't have a conversation after. So who knows what the truth is in that type of situation. But certainly, it's a little bit different than the corporate setting where you have time to really express yourself and know how to express yourself correctly. So I probably would still get out of the car and say, you know, is everybody okay? And express my empathy that way as to being worried about how everybody is, rather than saying, geez, I shouldn't have been texting when I hit the back of your car.
Yes. And for kids in the schoolyard, you're still going to counsel your kids to say, if you hit someone, say, I'm sorry.
Yeah. It's just, rather than a legal situation, it's just raising your children the right way. And if you do something as a child, take responsibility for it and learn how to take responsibility for it, so as an adult you can. But we now are starting to then step away from raising our children to now we're older, what do we do and how's the right way to do it? There is some nuance to all of that, but certainly empathy is okay.
Thank you. In a way, it's almost too bad that we have to have this conversation, but it's an important one to have. So let's talk about police and courts a little bit. Is it illegal to lie to an officer of the court, police, a detective, an investigator? And then the other side of that, David, is it illegal for the police to lie to you in their effort to solicit some sort of a confession?
So, two very interesting sides of that coin. So, if you lie to someone who's investigating a crime and that delays their ability to investigate the crime, it can be obstruction of justice. And certainly that's a crime that the police can charge. Now, there's a fine line as to what's obstruction of justice and what's just non-cooperation, I'll call it. For example, this goes back many, many, many years. I had a client who was working in a building in the basement on the oil burner or something. And the police come down and they're looking for somebody. And they said, did you see anybody come down here? And he said, no. And he just keeps working. And so they go along and eventually they find someone in the basement that they were looking for. So they arrest that person and they arrest my client and charge him with obstruction of justice. So, of course, that case was dismissed. Number one, when did the guy get down there? How did the police know if my client ever saw the guy go by or not? And what obligation does my client have to do, say anything? He didn't lie necessarily because he may not have seen the person. And how can they prove that he did? So that's non-cooperation. It's not obstruction of justice. But if you go to the police in a different situation where they ask you questions that you lie about, and you're lying about them because you're trying to delay or send them in a different direction, then you can be charged with obstruction in that case.
So your client was exonerated or case
Correct.
dismissed or whatever.
Correct. Yeah.
And then on the other side of it, David? The
So,
police?
you know, it's a state-by-state kind of thing as to that, unless it crosses over on the federal level as to, you know, violating someone's due process and that type of thing. But there have been instances where the courts, the Supreme Court, Rhode Island courts, other courts, have allowed a lot of leeway to police officers on what they can and cannot say. But I would argue that when it goes so far over the line, and what it reminds me of, you also have to look at the person you're dealing with, but there was that documentary on the murder in Wisconsin, Making of a Murderer, I think it was called, or something, where the nephew of the person who was accused of being the murderer was being questioned by the police, and they kept telling him, this is what happened, you did this, you know, to the point where they were putting words into his mouth and he didn't have the mental capacity to understand or deal with that, and so he just started repeating it back. That was found to have gone too far over the line.
Coercion or just?
Yeah, well, it's in that sense, it could have been coercion because of the length of the time of the interview, which is one of the things they look at, the methods that are used in the interview, what the person asks for in the interview, because of course, you know, they give you the rights, but do they actually let you exercise your right when you say, I want to talk to an attorney, I don't want to answer any more questions? Oh, that'll look really bad for you.
So
Can
what
they
do you
say
do with that? Exactly,
Yeah.
what do you do with that?
Well, yeah, obviously you're under a lot of pressure, but I would always tell my clients, don't answer the questions, don't care how bad or good it looks. You have your attorney there and have your attorney present while you're being questioned. And in fact, in that case, I believe, if I remember this correctly, the kid had a lawyer. They knew he had a lawyer, and the lawyer even said, yeah, go ahead and ask him questions, I don't have to be there. Really not proper representation.
Certainly.
So there is leeway, but there is a limit to that leeway.
So just to pick up on what you were saying about, I think I'm not going to speak anymore until my lawyer comes, and they chide you with, well, what is it going to look like? I mean, if you have nothing to hide, and what about if they really can't hold you? sure, you can leave, but if you leave, what is that really saying about your innocence, David? So what do you do with that? If you have the chance, you get to caution your client. But suppose, in this case, we're just speaking among ourselves.
Right.
What do you say to people?
Leave, if you can leave. If they won't let you leave, tell them you want your attorney there, and have your attorney there. And even if you didn't do anything, again, you don't know what kind of process it's going to be, how long it's going to take, what they're going to take out of other things that you say that really might mean one thing but come out a different way. So I would absolutely tell you, don't worry about how it looks, have your attorney there. Okay.
If police have arrested two or have detained two, your buddy, he's coming forth with all the he's going to bag you. Is that still yet another reason to say, thank you, I'm not going to say a word, get my lawyer?
Yeah, I would say it before you even got to that, because they always do that, right? Well, not always, but you hear those stories of, well, we arrested two of you, and, you know, he's talking in there. You might want to let us know what it is before he implicates you, and that's something that, it's a technique that can be used, it's been used, and you need to say, all right, I want my attorney here, and hopefully he has his attorney there too, and you just then have the advice of at least a level-headed person with some experience who can give you proper counsel.
And if, for example, the policeman had scribbled a name or something in the back room and put it in front of you as the detained individual, see, that person who was this victim, they said it was you.
Right.
You know clearly that it wasn't, and they couldn't have, or maybe they did try to, maybe the victim did try to put you in a bad place, but clearly you know that that's not possible, it's not the truth.
Right. Just scribbled the name down just before they died.
Yes.
And now you're being implicated.
Yes.
And yeah.
Ripped from the headlines kind of television show, for example.
Right. So yeah, again, have your counsel there. Let the counsel give you advice, and don't say anything, because you don't know how far they've gone over the line, close to the line. They're on the right side of the line, but they may or may not be telling you things that are at least 100% accurate.
Okay. And if you do end up having to go to court, is it legal for a judge to ask you to swear on an oath on the Bible?
So there are some people who don't swear oaths, so they'll affirm the truth of their testimony, and that's okay. You can affirm that you're telling the truth.
So when they set that up, please put your hand on the Bible. You say, no, thank you, but I will.
We'll affirm the truth.
Okay.
Yeah.
And what if you are then either chastised, or, for example, you're going to be serving on a jury, and then someone says, I don't think that they're qualified. I think we'll excuse them. Maybe you take offense to that. Can you take offense to being discounted for your testimony or your judgment based on, I'll only affirm, not swear on a Bible?
Well, you're allowed to do that. The judge can give an instruction to the jury as to how they're supposed to deal with that, if the judge feels it's necessary. Honestly, that's a really, that jury is really paying attention if they notice the difference between I affirm to tell the truth or I swear to tell the truth, because that happens so quickly at the beginning of the testimony. But what you do need to know is that whether you're affirming the testimony is true or swearing an oath that it's true, it's still testimony that, if it's not true, can subject you to perjury.
Good to know. Okay.
And that might be the instruction the judge would give the jury. This witness is affirmed, and again, I don't think it's necessary, and I don't think you want to highlight it and call it to the jury's attention, and probably wouldn't have to happen. But if there is a concern that the testimony this witness is giving is subject to all of the same penalties of perjury that any other witness would give, if it's even necessary, which I don't think it would be.
Okay. We've had discussions about whether or not you're able to sit out the Pledge of Allegiance or the singing of the Star-Spangled Banner. You're legally permitted to do that, right?
Of course.
So suppose you are working for someone and the handbook says, we stand, we sing.
All right. So now let's just say the only company I can think that might want to do that would be the NFL.
The NFL?
Yeah. So there has to be some accommodation. And the accommodation could simply be, if you don't want to do that, stay in the locker room, perhaps. Come out after we're done. Because the NFL has a right to say, in some ways, what's going to happen on their field. And if you don't agree with that, which you have a right not to agree with, they would then have a right to say, well, then this is how you're going to express your disagreement. Not in the public eye, not on the field. You can stay in the tunnel, for example, out of the camera's way or whatever. But it impacts their business, and it impacts all of the commentary that's going to go around what is going on with their game. So they have a right to somewhat regulate that, but they don't have a right to make you do something you don't want to do. So there has to be some accommodation given to you and your beliefs.
Okay, and you should read the handbook anyway.
Right.
Before you do something like this. How about in school? Schools, is it legal for schools to teach creationism, intelligent design, et cetera, in science class? Can they do that?
Is it legal?
Unconstitutional?
So I wouldn't say it's unconstitutional because just like someone who would be on the opposite side of that coin would suggest that you said
the creationism,
yeah.
Endorse the...
Right. Yeah, I don't think
from
a
whence it
school, a public school, necessarily should be endorsing some form over another, but they certainly can expose children to all of those things. And it actually is somewhat, I would suggest this, you teach evolution, you teach the other side of the coin there, you teach science. You can teach opposing views, and that can all be appropriate. And we know you're allowed to teach that because of our William Jennings Bryan and the Scopes monkey trial and all of that. So it is certainly arguable if you're going to teach one side, you should be allowed to teach the other. And it's not unconstitutional to teach the other side, even though one might argue, well, that's mixing church and state. It really isn't. It's teaching one theory and another theory. But I think you have to expose, you can't do one over, you can't teach a religious side of it and not expose the other side in a public school.
So it's okay to refer to in some way that supernatural creator as long as it's couched with or balanced by...
Right. There's
there are theories
there
that...
are other theories and explanations and thoughts, and when you start getting to those types of things, and then what about teaching sex ed at the school level, and what grade, and should parents have a right to know and weigh in, and I don't want my child to be exposed to that at this age or that age or whatever. I think communication with the parents on all of those things is a really important part of that.
Sounds right. School prayer, can't do it, right?
Well, that's what we've been told. Yep.
Graduation, can't
Yep.
do it.
Right.
You have a valedictorian, and she decides that they are going, it's voluntary,
Right.
whatever he's saying. Does he have a right to, if not pray, make some reference or allusion to said creator?
So I think that isn't the school-sponsored speaker.
And that's the difference, David?
And that is the difference, because you're weighing and balancing separation of state and church, which would be on our agenda. We have this prayer, then this prayer, then this prayer, and we're sponsoring that, versus the freedom of speech of a speaker who is invited to speak and has their own rights too. So I would argue that you can reference it. And it's now not the school saying to everyone in the audience, please stand up and recite this prayer with us. It's a speaker who doesn't have control over everybody else in the audience, but might be wanting to express a thought that he has to the audience, and he has that freedom of speech to speak about what he wants to speak about.
Good to know. And because we're having some of these discussions now, it's not surprising that more than ever, parents are considering that they want to homeschool their kids. Do you have to notify the school, the state, so that you don't have some truancy
Right.
officer on
Sure.
your door? What do you have to do?
You have to have a program, And I would suggest that not only do you have to have a program in place, but you have to have communication with your school system as to how you're implementing your program, what your program is, and maybe for your benefit, get some feedback from the school department of, okay, because you might be entitled to get some textbooks from the school as part of your plan. You might have other resources that they would provide to you in your plan. And there might be some other accommodations that could be made. For example, I want to homeschool my child, but I want my child to be able to participate in the school's athletic programs or extracurricular activities. Can we set something up like that? So it should be a conversation for more than just, I'm notifying you of what I'm doing, but what other things can be provided to you from the school system.
And you can ask about that. You are a tax-paying
Correct.
person, so why shouldn't you be entitled to tap into the education system?
Right.
Sounds right. On the work level, we have lots of discussion now about medical marijuana. If you're an employer, can a prospective employer refuse to hire you if you use legal marijuana for medical reasons? Right?
I would have to use some analogy there and say, can a prospective employer refuse to hire you because you're on depression medication? What do you think?
So I've been reading this, and it's very strange, but apparently they can legally refuse. It doesn't seem that it's real. It doesn't seem that that should happen.
Well, it's because it's so early in the legalization and use of medical marijuana world.
Yes.
But if it's being used as a prescription, I think an employment attorney can argue that that can no more be discriminated against than someone who takes depression
Prozac.
medication or another medication for arthritis or anything else that's prescribed by a doctor. Now, the use of it can be regulated at the workplace, I would think, because just as it's legal to smoke tobacco, they can say this is a non-tobacco workplace and you can't smoke in the building or within a certain number of feet of the building. They can regulate that. Just like you can take your medications at home, they can say you can't smoke marijuana at work even though you have a prescription because this is a smoke-free environment and that impacts other people who work here. I would assume if it's a pill or edible of some type that you have to take, that you'd be able to do that. But what they might be trying to say is, what is the impact of you to be able to do your work under the influence of the marijuana? But if it's being taken for a specific medical condition and you're able to do your job, then I don't see how, on the basis of your taking it, they can say, we're not hiring you. If you can't do your job, remember, most jobs are employment at will.
Right.
Can't do your job, you can't do your job. So I would argue that a legally prescribed prescription that's taken, whether it's Prozac, as you said, or something for another medical condition, or marijuana for another medical condition, isn't grounds in and of itself not to hire someone.
So there must be an employee bill of rights or something that's going to be changing, or maybe you need to look at the state laws regarding this, because it seems like this, as you indicate, it's going to be a floating issue and it's going to have to evolve because of the statutes such as they are now.
Well, you got a couple of different things, actually. You have the fact that right now, marijuana is still, I think, Schedule.
See?
Yeah,
Is it?
I think so. No, well, that might be a tax return.
Maybe that's a Schedule
But
A.
it's a scheduled drug
Okay.
on the federal government level. And as a scheduled drug, it's illegal federally to use marijuana. Now, states have said you can, certain states. So you have that conflict. And because of that conflict, an employer might be able to say, you know, federal law says you can't use it. We're not going to hire you because you're using it. So until all of that gets flushed out, even though I am jumping ahead and saying, nope, if it's legally prescribed, you can use it, you might be able to, as an attorney for the employer on the other side of that case, say, well, it's not legal federally and we have to operate under federal law. We have a contract, for example, with the federal government, and it prohibits. So that could be an argument. But in general, as these laws flesh out and as federal law eventually catches up to state law and that type of thing happens, that's when I'm going to tell you that it's really no issue. But there are issues, so I'll retract a little bit.
Okay. And in terms of it being possibly discrimination if you aren't hired, there's an awful lot of clamor about being discriminated against because of your age, past 40 or something. How do you actually prove that? They say that it's very difficult to prove that you've been discriminated against unless you actually heard your boss say, I won't hire or promote him or her because she's 42 or something.
Right. Yeah, and it's just like all other forms of discrimination. How do you prove it? And it depends on the situation and the company and everything else. But if you see a company that there's nobody over a certain age that ever gets a raise or a promotion, or that, take women for example, the company's always got 10 men to every woman who gets a promotion, or the women are making so much less money than the men. You know, all those different forms of discrimination, how do you prove it on an individual basis? Well, you really have to look at it more broadly on a company-wide basis. And that's really where you may find the smoking gun, so to speak, as to what's going on at that company.
So we say that at times you can handle some issues yourself. Is this an indication where you might actually need a lawyer who would trace the, I don't know, the patterns of employment or something better than an individual could?
Well,
is that a reason to?
Certainly, if you're going to bring in legal action on what you have seen in your opinion to be discrimination, you want to hire an attorney to do that, because you're probably not very familiar with the discovery process that you're allowed to use to find information, and the lawyer is. And so it's like any other litigation. Litigation is not something that you want to handle on your own unless you have to.
It seems that in many of these cases, in the short time we have left, it seems that in many of these cases there are so many nuances that it would be impossible for an individual to flesh that out themselves. Is that generally true?
Yeah, well, sure. And if you have an attorney that is familiar with the area, they also know what to look for and what things are out there that have been found in other cases to try to repeat and find again.
Sounds right. There were so many more questions I had. Maybe we need to follow this
Another
up later.
potpourri?
Another potpourri. We thank you for tuning in to The Law Matters. As we say, it matters to you. Thank you.